Summary of key findings. The Peace Officer Bill of Rights and its various state-level equivalents represent a complex intersection of due process protections for law enforcement officers and the broader public interest in accountability, transparency, and trust. Initially introduced in the mid-1970s to safeguard officers from arbitrary or politicized disciplinary action, these frameworks have since evolved into a widely debated cornerstone of police accountability debates. The central tension lies in reconciling the original intent to ensure fair treatment of officers, with subsequent criticisms that POBR statutes have, in practice, hindered the timely disclosure of critical evidence, complicated investigations, and restricted meaningful oversight. A key finding is that while POBR provisions were designed to prevent unjust termination and politically motivated discipline, their procedural requirements can slow or obstruct internal investigations and legal proceedings. Strict timelines, formalized interrogation rules, and confidentiality clauses, intended as procedural safeguards, often reduce the likelihood of misconduct allegations resulting in open court adjudication. This has contributed to a decrease in full trials of officers accused of wrongdoing and a more frequent reliance on settlements or administrative resolutions conducted behind closed doors. Critics argue that these conditions obscure the truth, limit public scrutiny, and undermine confidence in law enforcement institutions. Transparency emerges as a critical theme. Provisions that guard personnel files and disciplinary records from public view, though conceived to protect individual privacy and prevent reputational harm from unverified allegations, have inadvertently fostered suspicion that misconduct is being concealed. Researchers, activists, and civil rights organizations have documented how POBR-related confidentiality rules can prevent prosecutors, defense attorneys, journalists, and concerned citizens from accessing essential information. The resulting opacity hampers efforts to establish patterns of misconduct, test officer credibility in court, or propose informed policy changes. In response to these criticisms, reform movements have gained momentum. Civil society organizations, community advocates, and legal scholars have urged recalibration of POBR statutes through legislative change and the expansion of independent oversight. Such proposals seek to maintain fair procedural protections for officers while ensuring a more open flow of information to the public, the press, and oversight bodies. Initiatives to broaden access to certain misconduct records, relax blanket confidentiality rules, empower civilian review boards with subpoena authority, and standardize data collection on complaints and disciplinary actions are all intended to increase accountability without abandoning the core principles of due process. Law enforcement advocates offer counterarguments rooted in professional stability, fair treatment, and morale. They stress that POBR frameworks help maintain a workforce confident in its legal protections, ultimately benefiting the public by attracting and retaining capable officers. They also argue that due process protections do not preclude accountability. Rather, they ensure that disciplinary actions are fact-based, considered, and not influenced by transient public outrage or political expediency. Despite the clash between supporters and critics, a crucial finding is the dynamic and evolving nature of this policy arena. States have begun reassessing their POBR statutes, some enacting partial repeals or integrating reforms that promote limited transparency. Policymakers have introduced bills to relax certain procedural hurdles, grant selective public access to disciplinary records, and refine arbitration rules to prevent egregious misconduct from being shielded behind technicalities. Ultimately, the debates surrounding POBR reveal a fundamental challenge: how to protect officers' rights to fair treatment while ensuring that misconduct, when it occurs, can be identified, scrutinized, and appropriately sanctioned. Achieving this balance is not only a matter of legal architecture, but also of public perception and trust. Without meaningful accountability measures, the public may view POBR as a tool of concealment rather than a guardrail against unjust discipline. Conversely, without due process protections, officers may fear that disciplinary mechanisms will be used capriciously or politically. In summary, this expose has shown that the Peace Officer Bill of Rights stands at a critical juncture in the broader conversation about policing, accountability, and governance in the United States. On one hand, it embodies legitimate concerns about fairness and stability in law enforcement careers. On the other, it can function as a barrier to the transparency and accountability that communities increasingly demand. The key findings highlight a sustained push toward reform through legislative changes, enhanced oversight, and greater involvement of civil society, aimed at creating a more balanced framework. The ongoing challenge will be to refine these statutes so they uphold officer rights without compromising the public's ability to see, understand, and trust the accountability processes designed to ensure just, lawful, and equitable policing. Implications for the future of policing. The trajectory of the Peace Officer Bill of Rights and its evolving role within policing governance stands at the nexus of historical precedent, contemporary scrutiny, and future potential. As reform efforts continue to unfold, the implications for the future of policing are both profound and multifaceted. Policymakers, community leaders, law enforcement professionals, and civil society organizations will confront crucial decisions about how to recalibrate the balance between officer protections and public accountability. The manner in which these adjustments are made will shape not only the transparency and integrity of law enforcement agencies, but also the trust and cooperation of the communities they serve. A key implication for the future lies in the recalibration of procedural rules. As jurisdictions experiment with loosening strict confidentiality requirements, shortening investigative timelines, and refining evidentiary standards, they are effectively reimagining the conditions under which policing takes place. These shifts suggest that future iterations of POBR-like frameworks will likely be more responsive to public calls for openness, greater transparency in disciplinary outcomes, improved access to personnel records in cases of substantiated misconduct, and streamlined pathways for external oversight entities are poised to become the norm rather than the exception. Over time, such changes may reduce public skepticism and improve the perceived legitimacy of law enforcement agencies, creating a foundation of trust upon which more effective policing strategies can be built. Another significant implication involves the broader cultural and institutional adaptations needed within police departments. While legislative and policy reforms provide formal structures for accountability, lasting change hinges on how these measures are adopted and internalized by officers themselves. Departments that embrace these reforms as opportunities for professional growth rather than as threats may find themselves at the forefront of a new policing paradigm. Through enhanced training, dialogue-based internal reviews, and proactive community engagement, departments can foster an environment where accountability is not merely a regulatory obligation, but a shared value. This shift in organizational culture will be essential for ensuring that evolving legal frameworks generate tangible improvements in officer conduct, morale, and effectiveness. The future of policing, in light of POBR reforms, may also witness a more sophisticated interplay between technology, data, and accountability. As oversight bodies gain greater authority to access and analyze disciplinary records, data-driven insights will guide policy development, training initiatives, and strategic interventions. Law enforcement agencies that leverage technology to maintain accessible, accurate, and comprehensive databases on officer conduct will be better positioned to identify trends, allocate resources efficiently, and prevent recurring misconduct. This data-centric approach could, over time, diminish the reliance on anecdotal accounts and sensationalized narratives, enabling more nuanced discussions about the health of policing institutions and the reforms they require. Moreover, as states and municipalities learn from one another's experiences, the future of policing may reflect a convergence around best practices. Jurisdictions experimenting with community oversight boards, enhanced transparency laws, or innovative forms of dispute resolution and arbitration will share their successes and failures. This exchange of insights can lead to a more standardized baseline for accountability measures across the country. Uniform standards, while not entirely erasing local nuances, can mitigate regional disparities in accountability practices. Eventually, This could yield a more consistent experience for officers and communities alike, reducing confusion and cynicism about the fairness and predictability of disciplinary procedures. The evolving legal landscape also holds implications for interagency relationships and partnerships. The more transparent and fair disciplinary systems become, the easier it may be for prosecutors, defense attorneys, and courts to navigate cases involving officer testimony or alleged misconduct. If prosecutors can readily access relevant records and rely on timely investigations, they may be less inclined to avoid taking cases to trial due to evidentiary obstacles. Similarly, defense counsel could more effectively advocate for their clients' rights if they have equal access to essential information. This improved cooperation between law enforcement, the judicial system, and the broader legal community could enhance the overall credibility and fairness of the criminal justice process. Crucially, the future of policing under reformed POBR frameworks also depends on sustained civic engagement. Community members must remain involved in oversight processes, demanding accountability and monitoring the implementation of reforms. Persistent public scrutiny and informed advocacy will ensure that policymakers do not drift toward complacency or revert to more opaque arrangements. In this sense, the relationship between law enforcement and the communities they serve will continue to evolve as a dynamic partnership. Citizens who see their concerns reflected in policymaking and their input integrated into accountability structures are more likely to cooperate with officers, report crimes, and serve as witnesses. This positive feedback loop can make policing not only more transparent and equitable, but also more effective and responsive. In sum, the implications for the future of policing emerging from evolving POBR statutes and related reforms are far-reaching. As laws are adjusted, institutions adapt, and cultural norms within law enforcement agencies evolve, the very nature of policing stands to be reshaped. While challenges will persist, resistance to change, differing interpretations of reform initiatives, and the complexity of balancing officer rights with public accountability, there is a growing recognition that the status quo is neither inevitable nor unalterable. The reforms now underway point toward a future in which procedural protections for officers and demands for transparency are no longer seen as irreconcilable. Instead, they can become complementary elements of a well-functioning, respected, and just policing system that meets the evolving expectations of the public it serves. Final thoughts on balancing officer rights and public accountability. The ongoing discussion around the Peace Officer Bill of Rights and its effects on policing reveals that striking a balance between officer rights and public accountability remains a complex, evolving challenge. POBR statutes and their equivalents have, since their inception, aimed to protect law enforcement personnel from unjust treatment, political interference, and unfounded allegations. Over time, however, the practical consequences of these frameworks, delays in investigations, barriers to transparency, and difficulties in accessing evidentiary records, have illuminated their potential to unintentionally shield misconduct and undermine public trust. The growing body of scholarly research, advocacy reports, and legislative reforms suggests that achieving a sustainable equilibrium demands a thoughtful reassessment of how procedural safeguards interact with accountability measures. Central to this recalibration is the recognition that officer rights and public accountability need not be viewed as mutually exclusive concepts. The original intent behind POBR legislation was not to impede investigations or foster opacity, but to ensure that police officers, who operate under heightened scrutiny and risk, receive the procedural fairness akin to that afforded other public employees. Yet, as the policing environment has changed, amid mounting calls for greater oversight, data-driven reforms, and public involvement, what once seemed like prudent protections now raise legitimate concerns. Critics point out that extensive procedural hurdles and strict confidentiality provisions can insulate even repeat offenders from timely discipline, eroding the community's confidence that problem officers will be held to account. Walker, The New World of Police Accountability, 2019, ACLU, Gaining Compliance. A Survey of Proposed Police Reforms, 2020. The question, then, is not whether to protect officer rights or ensure accountability, but how to refine existing statutes so that both objectives can be realized in tandem. Reformers suggest that procedural fairness and robust oversight are not opposites. Rather, they can reinforce one another if properly designed. Imagine a framework in which due process rights remain intact. Officers still receive notice of allegations, have access to representation, and are judged according to clear evidentiary standards. Yet investigative timelines, disclosure rules, and disciplinary procedures are streamlined to prevent unnecessary secrecy and obfuscation. In this scenario, fairness for officers does not come at the cost of transparency. Instead, it coexists with mechanisms that allow oversight bodies, courts, and the public to ascertain whether justice is served. Achieving this balance, however, necessitates legislative and policy adaptations. The states that have begun to revise their POBR statutes provide instructive examples. Measures that relax blanket confidentiality provisions and grant the public access to substantiated misconduct records, especially in cases involving serious offenses, signal that accountability and transparency have become shared priorities. Likewise, adjusting investigative timelines so that neither rushed conclusions nor indefinite delays are tolerated can support thorough and impartial fact-finding. These reforms emphasize quality and integrity in investigations, rather than rigid procedural technicalities that risk obscuring the truth. In parallel, internal cultural changes within law enforcement agencies are just as essential. No matter how sound legislative changes may be, their implementation relies on the willingness of police departments and their members to embrace transparency and accountability as core values. Officers who view accountability frameworks as tools for improvement rather than punitive devices may become more engaged in internal reviews, more open to training that emphasizes ethical conduct, and more supportive of policies that encourage community trust. Leadership within departments, by setting the tone for openness and responsiveness, can help officers understand that updated procedures serve to enhance the credibility and legitimacy of their profession. In the long run, cultural acceptance of oversight can reduce resistance to reform, turning what once seemed like external impositions into respected professional standards. Law enforcement unions and associations, historically staunch defenders of POBR protections, also stand at a crossroads. While they have every right to safeguard the interests of their members, unions can also recognize that public perception matters. If communities regard POBR as a shield for misconduct, the reputation and effectiveness of law enforcement as a whole may suffer. Unions that engage in constructive dialogue with lawmakers, advocacy groups, and community representatives can help shape reforms that preserve essential due process rights while removing unnecessary impediments to accountability. By proactively participating in reform debates, unions demonstrate that they too value fairness, not only for officers accused of wrongdoing, but for the public that invests its trust and resources in policing services. Moreover, as data collection and analysis capabilities advance, reliance on empirical evidence will inform future reforms. Comprehensive, standardized record-keeping of complaints, disciplinary outcomes, and arbitration decisions provides a factual basis for evaluating which procedural rules promote fairness and which produce unintended consequences. Over time, as more jurisdictions test different approaches, granting oversight boards subpoena power, requiring the disclosure of certain files, or adjusting arbitration clauses, researchers and policymakers can compare outcomes and refine best practices. The iterative nature of this process suggests that the final equilibrium will not emerge suddenly or uniformly. Instead, it will develop gradually through informed experimentation, legislative innovation, and communal engagement. The courts may also continue to influence the evolving landscape. Judicial rulings that clarify constitutional boundaries, interpret statutory provisions on disclosure, or uphold the necessity of transparency in certain cases can steer POBR reforms toward greater accountability. When courts endorse the notion that certain forms of misconduct evidence cannot remain hidden indefinitely, they reinforce the idea that officer rights must coexist with the community's right to know when policing standards have been breached. Judicial oversight thus becomes another safeguard against the overreach of confidentiality and the underenforcement of accountability measures. Civil society organizations and advocacy groups, having championed POBR reforms, remain crucial to ensuring these adjustments stick. Their role in educating the public, mobilizing community voices, and monitoring compliance helps maintain the momentum for change. They will continue to serve as external watchdogs, making sure that once promising legislative reforms do not stagnate or revert to the status quo. Their persistence reminds policymakers and police departments that true accountability is not achieved simply by passing laws, but by faithfully implementing them and revisiting them if they fail to produce the desired outcomes. The implications of finding a workable balance between officer rights and public accountability are far-reaching. Improved transparency can fortify the moral authority of law enforcement agencies, fostering cooperation between police and the communities they serve. Enhanced accountability measures can deter misconduct, encourage best practices, and ensure that when wrongdoings occur, they are neither hidden nor excused. Simultaneously, maintaining fair processes and representation rights can help recruit and retain capable officers who trust that the system will not sacrifice them to political expediency or public anger. The resulting equilibrium, if achieved, would yield a more stable, respected, and effective policing institution that meets the standards of both democratic governance and professional integrity. In the end, the pursuit of balanced reforms to POBR and similar frameworks underscores the dynamic nature of policing in a democratic society. Norms, expectations, and best practices evolve as public awareness increases and social conditions change. Far from being static documents, POBR statutes must remain responsive to new understandings of accountability, fairness, and public interest. By continuing to test, revise, and refine these laws, stakeholders can move closer to a reality where officer rights and public accountability do not conflict, but rather contribute jointly to the effectiveness, legitimacy, and moral soundness of American policing. As these reforms mature, they will not only influence the daily work of officers and investigators, but will also shape the broader legacy of law enforcement for generations to come.